This meeting is being recorded. This meeting is being transcribed.
Good morning, members, everyone watching and participating through Teams. My name is Roxana Gamusio. I am the Executive Director with the Court Reporters Board. Today is Friday, November the 17th, and it is 9:01. We are going to get started with the scheduled meeting. Before we proceed, I want to go ahead and take roll call to make sure that we have quorum in person. When I read your name, if you could just let me know you're here. Britton Collins.
Here.
Thank you. Ken Mansfield.
Here.
Thank you. Morgan, Marilyn Morgan is not with us today. Brandon Pettis.
Here.
Thank you. And Judge John Rambo.
Here.
Thank you. We have quorum in order to proceed. Notice of this meeting was properly put on the board's website. The date and time was put on since December 9th of 2022. The meeting was originally scheduled for September 29th. We did not have quorum for that meeting, so it was moved to today's date. And the agenda for this meeting has been on the website since November the 8th. I would like to take a minute to introduce two of our attorneys under the program. Jesse Gentry is Chief Counsel with the regulatory boards, and he has been assisting. Hugh Cross was our attorney and has moved to bigger and better things outside of commerce and insurance. And so taking his place as our board attorney is Joseph Wharton. Jesse, anything you or Joe want to say to the board?
No, we're just excited to be here, and Joe's going to do a great job. I have the privilege of presenting the legal report today, and moving forward, Joe will be handling that and board business as well.
Thank you. Just want to remind everyone before you speak to make sure that the red button is on so that we can get you on the record. The first item of business is the members were sent via email, of course, the redacted legal report and the agenda for your review. I would need a motion and a second to present the agenda as it's been posted. If we have any modifications, we can also do that, of course.
So moved.
Thank you, Judge.
Second.
Thank you. We have a motion by Judge Rambo and a second by Ken Mansfield. Everyone in favor, please say aye.
Aye.
Thank you. Any opposed? We are good. The next item is going ahead and accepting the April minutes. Those items also were emailed to everyone ahead of the meeting. If you have any corrections or amendments, please let me know. Otherwise, if there are no changes, we would need a motion and a second to accept the April meetings. Minutes.
So moved. Second.
Thank you. We have a motion by Brandon Pettis and a second by Ken Mansfield. All those in agreement, please say aye.
Aye. Aye.
Any opposed? Thank you. On your iPads, we're going to start with the director's report. And give me just a minute to get to. It is on page 6 of the 55 pages. This is a relatively short meeting with the exception of the sunshine presentation at the end. So at this point, we have fiscal year closures for 2023. That document on page 6 will reflect the 4 years. So those are final numbers. It reflects that the program had a deficit of $45,401, leaving the reserve at $146,507. As you can tell from the 4 years, every other year based on the renewals course, we have a deficit because it's not our renewal year. It is double, if not triple, what the deficit the prior renewal was. But again, we still have a surplus. Just general information. Any questions regarding the budget?
What happened between the 1920 fiscal year and the 2021? And then the years thereafter for the legal cost backs? You know, in 19 and 20, it was $7,630, and then the next year it jumps to $26,000, and then it's 38, and then 30. Is there just been a change in the way that those have been expensed back to the board, or has there been a material change in the amount of legal work that's being performed on behalf of the board, and what does that look like?
Thank you. I don't have the breakdown of the cost back for legal. I can say that there's been somewhat of a change in how it's distributed. Also, an adjustment to salaries has been made that impacted the last part of fiscal year 2023. That wasn't just to legal. It was across the board to all. Most state employees had our wages compared to other states and other industries didn't even come close. And so that adjustment was made and would have impacted the legal cost backs as well. But I can get you more details on anything else. Happy to share that.
Yeah, I mean, our reserve balance is going to dwindle over time. We don't have as many renewals as we used to. Legal looks to be by far our highest expense item, and it quadruples from 19 and 20 to 20 and 21 and then stays up. And so, I think as a board, that's probably, if we didn't have that elevated expense, we wouldn't have a diminishing reserve balance. And so, I think kind of understanding what that expense is, if there are ways it can be controlled, because otherwise, at some point in time, we're going to get to the point where we're going to have to increase fees, which prefer not to do if we don't have to.
Couldn't agree with you
So
more.
I'd just like to understand
Right.
what happens between those
With that.
2 years and why it stays elevated.
Absolutely.
If-
Absolutely.
If that can be something we can look into for maybe the next meeting.
Yes, I will put together some type of a report that explains what the change was. Again, I know a portion of that was adjusting salaries, so got that noted. Absolutely, I appreciate that. The other item of business under the director's report is the approval of our 2024 meeting dates. So you have those on page 7. Currently, we've got, we're sticking with the March and September dates as our attempt for board meetings. March 22nd would be that Friday, and September 27th. I would need a motion to go ahead and accept these 2 dates, and I'm happy to send out these dates if anyone needs them directly, or you can jot them down. But for now, that's what we'll post on the board's website for the calendar.
Motion to accept.
Thank you. We have a motion by Ken Mansfield and a second by Britton Collins. All those in favor, please say aye.
Aye.
Any opposed? Thank you. That takes care of my portion. I'm going to turn it over to Jesse Gentry and Joe for the legal report.
All right, great. You should see in your packet the legal report starting, it looks like on page 8. This one has scroll down a little bit too far. So if you'd like, we can just start with each one. I know this legal report is a little bit longer than it is at times. We've had several complaints on here, plus with the meeting date being moved, I think it added an extra one that was received since then. So we can start with case number 1. It is complaint number 2023031971. I'll give you all some time to review this, and then if you have any questions, I'm happy to discuss them before we discuss the recommendation and the decision of the board.
Questions for me?
There are no questions. The recommendation for this case is to close it with a letter of warning regarding professional standards and preservation of notes. If you all would like to, either we can vote all together if there are no changes, or we can do a roll call vote or any deliberation.
Move to adopt council's recommendation.
Second.
Thank you. We have a motion to accept legal counsel's recommendation by Britton Collins and a second by Mr. Brandon Pettis. All those in agreement, please say aye.
Aye.
Any opposed? Thank you. Go ahead.
All right, the next is case number 2 is complaint number 2023031871. I'll give you all a minute to review that one, and we discuss if there are any.
Close. Second.
I actually have a question on this one, if you don't mind. I guess I'm a little confused about how we get to the recommendation. A complaint is made, the reporter is contesting it. There's some representation to us about what is or isn't in the evidence that's been presented. not impugning your work, but we're just, I guess, supposed to accept that. But there's a dispute here about what happened and what didn't happen, which seems like the exact circumstance in which you would have a contested case hearing rather.
Well, I think that,
So when you say no evidence of inaccurate services, I guess I'm looking for a little bit more about how we get to that conclusion so that we're not just kind of dismissing this person's complaint, maybe unfairly,
right.
just based on kind of the limited process that gets us to where we are. And
No,
the fact
I
that
understand.
we don't participate in it, so we don't have any insight into it.
Right. No, that's a great question. When we review all these complaints, typically if we don't have anything to even just get to the level where we would need to be able to substantiate, these cases, we'll ask for evidence. We'll ask for copies of orders, transcripts, notes, whatever we need. I will say that on this one, after the complaint was made, the court reporter did provide all of her file essentially for this, and we did review that. It is difficult at times when someone says this is inaccurate. We obviously are not at the proceeding, so we're not hearing everything that's said on the record. So when we're looking at the notes, looking to see, does this, make sense? Is this written out in a way that would, make sense in terms of direct responses? We are looking at all of that to make sure that it does appear to be accurate. If a complaint can give us a specific instance of saying, this is where it was inaccurate, this is how it ended up showing, maybe it didn't appear in the order correctly because of this.
That was my question, if I had one, which is they provided you motions and orders which aren't related to a transcript, but when you review a transcript, you can list your exceptions to it. Did she or the complainant provide the exceptions?
No, not necessarily. There was a few items where she said that there were disputes over words being allegedly changed. If it was something where there was a recording that we could have listened to with it and tried to compare and contrast, but at the time, this is the record that's been established, and it really aligned with what was in the court records as well. So I think that the appropriate venue at this time for the complainant would be through the actual court case and to contest, whether it was on appeal or any other avenues that she.
For case 2, we have a motion by Judge Rambo and a second by King Mansfield. Do your motions stand to agree with? Thank you. All those in agreement with the recommendation from legal counsel, please say aye.
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 Any opposed? Thank you. We'll proceed to number 3.
All right, number 3 is complaint 023033951. I will give you all.
I have a question about this one. I just procedurally, was the deliberative process, I guess, in terms of us looking at the complaint and trying to determine whether there was indeed some inaccuracies or something fraudulent, as the complainant says, was it the same as in the previous complaint where you've gathered the evidence, you've looked at?
I would have to look at the file again to see the exact extent of what all was received on the two of them. I will say on this one, I believe we did look at some of the information that was provided. So I think this one gave some specific items that they were contesting that were from the transcript that they had said, no, that's not as how it was actually stated. There really was not any evidence of a conspiracy, and I do believe they actually did correct an item that was part of the transcript, but this was the allegations of fraud or a conspiracy. It was hard to decipher there based on looking at a record of a court reporter to see if there was actually that type of wrongdoing. Yes.
Complainant not identified by category. For example, is the complainant, if you can tell us, an attorney, or was this a self-represented party who feels like they there's some conspiracy against them in their lawsuit and the other attorney. And the reason why I asked that is because if there were two attorneys, you could ask the other attorney, hey, is your client in left field on this or not?
I would have to double check on that one. I don't want to say without looking at my notes on that to see what their status was.
If I could comment, it seems reading the complaint that this would have been a deposition. Tennessee Rules of Civil Procedure require that all depositions must be read and signed unless that is expressly waived at the time of the taking. Now, so either this person waived signature, which meant he trusted the court reporter to get an accurate record, or he had the opportunity to read and sign, or he or she, and he could have, or she could have corrected any inaccuracies they wished to at that time. So it seems like.
And it was a deposition, that's correct.
Move to accept council's recommendation, close case number 4.
Second.
On case number 3, I believe, are we on 3? Thank you.
Yes.
Excuse me, I'm sorry, case
That's
3.
okay, I do.
Sorry.
We have Britton Collins accepting legal counsel's recommendation, a second by Ken Mansfield. All those in favor, please say aye.
Aye.
Thank you. Any opposed? Thank you. We are now on case number 4.
All right, case number 4 is complaint number 2023039931. I will give you a minute to look at the summary there.
Move to accept council's recommendation, close.
Second.
Thank you. On case number 4, we have a motion by Britton Collins, a second by Judge John Rambo to accept. All those in favor, please say aye.
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 Any opposed? Hearing none. Number 4 is accepted. We are on to case number 5.
All right, number 5 is complaint number 2023042381. Helpful if you want to look at 5 and 6 together. 6 is complaint number 2023043301. They are different complainants, but they are the same court reporter, same respondent.
Yeah, I was going to ask if we could consolidate the discussion on these two. You know, I'm a little confused about the recommendations on these. Well, so let me first make an observation. With respect to complaint number 6, the complainant appears to be complaining about something that occurred in February of 2021. By statute, complaints have to be raised to the board within 90 days of the activity, which is the basis of the complaint. So it would strike me that this complaint is untimely and that we don't have jurisdiction to consider it. So I would move to dismiss complaint number 6 on the grounds that we can't consider it. That said, in complaint number 5, we have the same court reporter 2 years later, or actually unlicensed, I guess expired licensed court reporter 2 years later continuing to perform court reporting services. Now, the recommendation is authorize formal charges with settlement through a consent order and a $250 civil penalty for unlicensed court reporting. I think the civil penalty recommendation is too low because we obviously have somebody who's been doing this for years, and by both statute and our rules, each day of unlicensed reporting is an additional violation.
Possibly each event, each occurrence.
Right. Sure.
Multiple times a day.
Well, I think the rules say each day. So, nevertheless, so we have somebody who's ostensibly doing this for maybe years going on, and so I don't think a civil penalty of half of what the rules would call for would be appropriate. But I'm also confused because there doesn't seem to be, through this recommendation, any attempt to redress the underlying complaint in 5, which is that the court reporter didn't, at least the way I read it, that the court reporter has not provided all of the transcripts that they were contracted to provide, which is a separate violation of our rules from the lack of licensure. So there's really 2 issues buried in this complaint, but the way I read the recommendation, it seems to only address the unlicensed court reporting. And I guess even though my observation is that complaint number 6 is no good because it's too old, it would strike me that also as part of the inquiry into complaint number 5, you could look back and say, okay, how many times have you been doing this? So, you may be able to get to it just through another direction.
Use it as an enhancement, possibly.
I think that would be appropriate. I mean, this is somebody who, based on what we have here, let their license expire in 2018. We're in 2023, and we have 2 complaints against us suggesting that court reporter has continued to engage in court reporting. Would strike me as pretty continuously since their license expired. They were aware of the rules. They previously had a license, so this is not someone who can feign ignorance on the subject. So from an unlicensed court reporting standpoint, that strikes me as maybe perhaps the most egregious case we've seen since I've been on the board, compounded by the fact that this person's also not providing transcripts that they're required to provide. So it strikes me as a bad actor, potentially, if all of this is true. And so $250 civil penalty seems weak to me under the circumstances. So I'll make that observation. Let anybody else provide some feedback if somebody wants to take a different position, and then I'll noodle on what I'd like to make a separate motion. But my preference would not be to accept this recommendation, but would be to suggest something stronger. And if the court reporter wants to contest it, then they're more than welcome to.
I got a question. At what point do you file an injunction precluding this person from practicing as a court reporter? And second, how do you disseminate the information that this person is not licensed so that the users, the attorneys, and the judges know that this person should not be hired until their license issue is fixed?
Right, and I think so. There's 2 potential avenues there. One, the first obviously is our licensing database is open to the public, so they could, any attorney essentially or pro se litigant could use that to see if someone has an active license. If you search this individual, it does show an expired license. There's nothing there where our system is in. Be disciplined. Go up on our discipline. So that would be typically, if you that does show up in the. You could see that as it relates to an injunction. I'm not aware of this board having pursued an injunction before, but I do think based on the nature of the violation, that if this was something the board did want to consider pursuing, we would have to the Attorney General's office.
And that was my point too. This is a Class C misdemeanor to practice without a license. And so I think we should pursue that route, and along with an injunction to not practice any longer.
And I will also add, just from history with other boards and programs, typically when we are referring things to outside agencies, whether that's, we've got, someone who's engaging in, whether it's the misdemeanor or, contractors, for example, we see this pretty frequently where, there's other potential theft or fraud. More often than not, I will say that when we make a referral, we are asked what disciplinary action the specific board has taken first, to kind of see where that is. So if we did pursue, whether it's through a consent order, if they agreed to discipline, or a formal hearing before the board or an administrative law judge, that order, then at that point, finding that person having committed that act, typically is a little bit stronger when we make that referral to pursue other options as well.
Sorry, go ahead, Judge.
Has this respondent either renewed their license or stopped the practice of court reporting voluntarily.
They have not renewed their license. I'm not aware as to whether they have stopped. Based on they did receive both of the complaints. We sent them to them, and we did not receive a response from the respondent.
And as far as one other point, as far as the statute of limitations, isn't that the responsibility of the respondent to raise that issue if they've filed no response?
It would be their responsibility. You know, when I looked at it initially, I think we probably are outside the scope of it. I had reviewed it maybe not as in depth as I could have, because I thought it was saying with a licensee that they are the ones who are entitled to that. Technically, it does say all complaints.
And it really gets to subject matter jurisdiction, right? Which can't be waived and can be raised at any time. So and can be raised sua sponte by the board or the judge. So I think
we probably would need to close 6. I think that's.
But I think we can get to it.
Right.
35.
And I think that's something too. We are able to pursue a civil penalty of $500 per violation. So I think that through the course of, if this individual is savvy, they would pay the penalty, get licensed, and try to make this something in the rear view mirror. But I think if we got to a formal hearing, what we typically do is, through our discovery process, we are asking, what other instances there are, and if we need to amend pleadings to add additional violations, we are able to do that with relative ease. It does make it difficult when you have an individual who so far has not responded to any of those inquiries, but it could also be a situation where maybe we need to ask other attorneys in this jurisdiction if they have pursued their services as well.
That sort of goes to the question I had. When Mr. Mansfield was talking about enhancements, clearly there's a 5-year lapse between when this individual's license expired, and there are these 2 separate violations, one of which is probably untimely, but there are 2 that we know about because there were formal complaints that were made. And ostensibly, this individual has been continuing to practice without a license over that entire period of time. And my question was simply, was there a way that we could find out whether there were other instances where this individual is rendering services so as to enhance that civil penalty to get to where Mr. Collins was talking about? Because I agree that, this does appear to be sort of a serial kind of bad actor. And, I think that penalty has to be sufficient under the circumstances to let this individual know that this isn't acceptable under the law.
Right.
I think at a formal hearing, we could request their appointment books for the time that they've been without a license, see how many violations there are. This could lead to possibly a settlement with a larger fee or an injunction not to practice and referral to the Attorney General's office in pursuit of the paying all these things, getting a license.
Right.
So I think we should proceed with the hearing.
Would you like to, typically we authorize a settlement offer. Would you rather just set this for a formal hearing?
So I have a couple more procedural questions, if you don't mind. One, am I understanding correctly that we would not be required to go through an administrative, if we didn't want to, we would not be required to go through an administrative hearing as a prerequisite to engaging the Attorney General's office for injunctive relief? I understand from your comments that it's helpful, but is it required?
I would have to look at that specific issue a little bit more in depth. I don't believe it would be required. I'm not sure if the Attorney General's office would pursue it if we had not.
And then second, this is my ignorance under the APA, but would an administrative law judge have authority to enjoin the unlicensed reporting?
I don't believe they would have that authority.
Yeah, it doesn't strike me that they would,
Right.
But
Right.
I don't do this every day, so.
I think that they would be limited to, typically assessing a penalty, assessing costs, and, there's no license to revoke here in this situation.
Right.
But and that kind of does bring me to another question as well that I wanted to ask the board specifically. Each of our boards typically decide which cases the board would like to hear or they would like to assign to just an administrative law judge. And some boards will have kind of a hybrid model where they'll have some cases for unlicensed activity, for example, heard by an ALJ alone, and then other cases involving conduct heard by the board. Some boards want to hear every case. I'm not aware of, from looking back at my records, the last time that this board heard a case.
Yep.
That was my understanding. So, how would this board like to proceed with the formal hearing, just so that way I can make sure that I'm, setting everything timely in case. Would you all like to hear this matter?
Methods the quick.
Well, and that also comes down to, we can set it for a case before the board. Typically, we do those at our board hearing dates, but if you all have a different date that you would like to set aside for a hearing, I'll use the contractors board for an example again. They typically use their meeting date, and then the day after, they'll also set for hearings if they need it, because they'll just have that standing hearing date. If you all would like to meet, if you would consider setting before this board at a that way. Or we could set it just in front of an administrative law judge, and that would work in the schedule of the parties with the ALJ.
I really think we should try to get to the Attorney General and see if they will accept it, because it's going to have an enhancement factor, especially if they can get their appointment book, because every violation has a fine. This could be that would be a good idea. And perhaps we should do that, and along with scheduling a formal hearing as well, to show the Attorney General that
that could be part of the recommendation, is to refer this over to the Attorney General's office for a potential injunction. And if it's a situation where I've made referrals to district attorneys' offices, and they've said, we're not going to pursue it. So if it's something where we refer it over to them and they decide, no, we would like you all to proceed with your matter first, then we could at least know that information.
I'll make a motion we have a formal hearing.
As part of the motion, do we need to make a determination about whether it's going to be, are you wanting the formal hearing, Ken, to be conducted in front of us, an ALJ, or the hybrid model as you should, and under the hybrid model, we'd have an ALJ who would kind of oversee the process, but the board would serve as the fact finders, correct?
Right. So typically when we have it before a board, the ALJ is sitting there, they're making any pre-trial determinations that need to be made, determinations for evidence if there's something that needs to be excluded, but the board makes the ultimate decision.
If we went either the ALJ model or the hybrid model, do we as the board get charged for the ALJ's time and any expenses? And as part of the if the ALJ ultimately determines that this expired licensee has broken our rules and regulations and statute, assesses civil penalties against, et cetera, are those costs then assessable against?
They are.
Against the respondent, or do we just have to eat them at the expense of all of our licensees?
No, they can be assessed against the respondent. And if you did decide that you wanted this matter to be heard just by an administrative law judge sitting, on behalf of the board, essentially, that decision could be also reviewed by the board. Typically, our boards don't step in and overturn those decisions. They could, though, if there was a consideration that maybe the administrative law judge didn't get it right. The board wanted to hear it separately. So that is one matter of review as well. If you all wanted to have an ALJ kind of have first crack at it, I guess, and hear it. Maybe it's more efficient to do it with some of our boards that do it that way. But if it is something where, the board feels strongly that this is a matter the board would like to hear, maybe there is information in terms of the practice of court reporting that the board can serve better as a subject matter expert with determining, the nature of the violation and the actual harm to the public, that maybe an administrative law judge who doesn't hear. Those are all kind of the determinations that our boards make when they look to see if they should.
Maybe more. I mean, they're either engaged in court reporting or not. I don't think that's a complex issue.
Who's responsible for prosecuting the hearing?
It would be Probably Joe.
But it's your
will end up
office.
here. It will be us.
Okay.
Mhm.
All right. It's not the complainant's responsibility.
No.
Okay.
That's
We've never had one of these, so,
No, that's a good question.
Not sure how the process
and
fully
most of our
works.
complainants, I think, at times think that we represent them, and we have to be very clear that we're representing this matter on behalf of the state and taking it to a formal hearing. So any costs that are assessed against a respondent, any penalties are assessed against a respondent, those go to the state. They do not go to the complainant. But typically it is something where those orders, I will say, other agencies or other individuals, if they have a private action, are able to look at those because they're a matter of public record, and it might assist them in separate matters. This type of a situation, I don't know if there's if the complainant is looking specifically to file anything separately, but they might.
If we deferred this strictly to an administrative law judge, do we have the ability to make requests for specific findings of fact? For instance, it sounds like we're all quite curious. How many times have you done this? Because that seems highly relevant in this particular case. The ALJ may not be as concerned with the number of times as maybe we are. And so he or she may say, okay, well, yeah, this person did it 30 times, but I'm going to do a $500 penalty. It strikes me that probably most people on this board wouldn't find that to be sufficient. And so we might want to review the ALJ's decision and enhance it. But you can't do that if you don't understand kind of the full extent of the underlying facts. And so make a request that the findings of fact include something to that effect, and that the inquiry that your office conducts as part of the hearing, assuming that the respondent shows up, would get at that question.
And that's what we have. I will say more recently started to look a little bit more aggressively, maybe with our discovery process and trying to figure out the extent of violations. But that is something we can request it. The judge can issue a order to compel evidence. But again, if this respondent just completely fails to cooperate with any of that, it does make it difficult in terms of showing the extent of the violation. But maybe it does help, if we looked at any of these other offices to get them engaged as well. I will also say, with this complainant, on number 6 at the very least, they are a licensed attorney. So even if that case is being closed because of a lack of jurisdiction, it could be a situation where they may be aware of other instances. So, I will say that we will still pursue that as an option for determining additional violations if possible. Yes.
Attorneys that are calling actual with staff member, whatever level or title, calls at community, talks to a few. Practice, of course.
It does depend. We do have investigators on staff who will go, and for some of our other boards as well, they have specific inspectors that they use contracts to set up as well if they need a subject matter expert. But we do have investigators on staff who we can send to ask if they need to go find additional evidence. I will say for a case like these types of questions are ones that we can kind of determine with legal. Maybe we don't need to send an investigator out to get additional statements, but if we felt like we needed to kind of have that additional legwork done, we can have it assigned to an investigator.
Would it be feasible, if we wanted to refer it to just an ALJ, would it be feasible to have that process done in advance of our March hearing? So that we could have the order there to review and make our own determination, so that it's not a year from now before we're making a decision on this?
Trying to think that the last case that I set for an ALJ alone hearing, they set for a January court date, and this was filed earlier this month. So it is possible. I mean, they've got 30 days. They have to be served with at least 30 days before the hearing date. So it will depend on the schedule of the ALJ. Service of process, I don't anticipate being a major issue on this one. We know that this person does have a business. We'll serve them. It's possible to get a hearing date in February. I'm not sure if we'll get an order done before then. I mean, we would draft a proposed order, but making sure that it's signed and filed before then.
You mentioned something about discovery a little bit ago. How extensive can discovery be before a hearing such as this?
You can send interrogatories if we needed to, and we do send those on cases. And that is something where, when we feel like there might be a per day violation or multiple violations, the statute for or the requirement for yours is a $500 per violation penalty maximum. So I will say, when we do take these cases to a hearing and a judge looks at, if it's one violation, maybe the maximum is not warranted in that situation. If it's a per day, sometimes they look at that aggregate and say, well, maybe we're not going to do the maximum per day, just add up pretty high at time.
So you can have a production of document requests and ask for their calendar or their appointment book or some other document verifying dates that they've actually done work as a court reporter while unlicensed.
Right. And we can ask for all that. Again, if they fail to turn it over, that's where our process sometimes is a little bit limited in terms of what we can actually do. But I think that these are questions and this is information that might help if we did look to send this to another agency.
Make a motion that we proceed to a formal hearing.
I've made that motion.
Right. Yeah. But have it referred to an ALJ for adjudication, but reserve the final approval of the order and any penalties to be assessed to the board's review at our next hearing following the issuance of the order by the ALJ.
We're still deferring, I guess, to the ALJ to make that order. You just want to have the authority to review it. Is that correct?
My motion is that the ALJ would perform the hearing, make the order, but that we would review the order before it would be final and issued to the respondent.
Okay. Because when they issue it, it would be an initial order, and that becomes final unless the board feels otherwise. So you would still have that right even without that. I just want to make sure I understand what your motion is, though.
I want the board to be able to review the order before it becomes final, so that if we determine that the ALJ has under-penalized, that we have the ability to review and modify that before it becomes final.
I understand.
Okay.
In the event that, and I'll just give everyone I don't want to say put on notice because that sounds too formal, but in the event that it is not a situation where this order is issued, say the judge issues the initial order March 23rd, I think the meeting is the 22nd. We can work with making sure if we need to set an emergency meeting by the board just to make sure that time doesn't lapse for review. We have 10 days for review.
If I could, your mic is
Further up.
okay, good. If I could just clarify, we had a motion by Ken Mansfield and a second by Judge Rambo, and I believe this one is amending it a little. Are you okay? So that first motion and second would die, and we would
Yes.
go with Britton Collins' motion.
Suppose we said that. I know that's going to happen.
And Judge Rambo's second. Any other conversation? I didn't want to interrupt, but since we had a motion in play, I wanted to make sure that.
I'll withdraw my second to the first motion.
Going with Britton Collins' motion for a formal hearing, it would be heard by an ALJ and follow the procedures that we do with all of our programs when just an administrative law judge hears those. And then the board would have the right to review that order before it's considered final, specifically to look at the civil finding. There are no other questions.
Second on that.
We do. Judge removed it from the first done. So we have a motion by Britton Collins and a second by Judge John Rambo. All those in agreement with this motion, please say aye.
Aye.
Any opposed? Okay, hearing none. I think you've got notes too.
I do.
That would take care of 5. And I believe, do we need a motion and a second for closing number 6?
We do.
So moved.
Second.
On number 6, agreeing with council's recommendation to close, we have a motion by Judge Rambo, and I apologize. Who did the second? Britton Collins. All those in favor, please say aye.
Aye.
Any opposed? That takes care of number Jesse, back to you. Our last item, well, one of our next item on the agenda is the Sunshine Law presentation. I'll turn it over to Mr. Gentry.
All right. Could have on your iPads the Sunshine presentation. I won't read it all verbatim. This should be a review for all of you. But typically we'd like to do every year just an annual review of the Open Meetings Act and determine or discussion about what are public records, what are open records, and then what are not, and what can be does not need to be. Typically, our open records includes any documents, media, electronic data for processing files, other materials regardless of the physical form, and then as long as it's made, or as long as that document is made or received pursuant to law or ordinance, or in connection with the transaction of official business. Public records do not include devices or equipment where the records are displayed, so that is something to be aware of. But any documents, essentially anything that could be stored on those devices, can be subject to public records and a public records request. And then also, when we look at our Public Meetings Act and what are considered public meetings, meetings are of a government body and they should be held and open in order to comply with the intent and spirit of the Sunshine Law. A meeting is just any, I hate to use the word in the definition, but it is a meeting of a governing body or a public body for which a quorum is required to make a decision or to deliberate towards a decision on any matter. And as part of that, it is required that we give notice, we post an agenda, and the public be able to attend, and that there are minutes from that. If there is a decision that is made in violation of that, that decision can be null and void, and would have to be made in a public meeting. One thing that is important, chance meeting, public or not public, subject to the Public Meetings Act. Obviously, if you're discussing board business, and that if you run into each other, out in the public, and you say, "Hey, we've got this case coming up on our legal reporter. We need to discuss this type of an issue." That's a concern. You can't make a decision that way. Obviously, if you run into public, you don't have to punch or you appear in court before someone that is those are things that, as long as you're not discussing board business, is not going to be an issue. It's not going to be covered under the public. And again, this applies to every board and every commission. You are not the only board that has to comply with the Public Meetings Act. Typically, some of the things that are not included in that also would include, if there was a executive session, if the board was being sued, for example, and there needed to be a discussion about, the legal rights of the board, that would not be considered a public meeting. That's something that can occur where everyone is made. And it doesn't have to be the full board to be considered a public meeting. It could just be 2 members. So again, you shouldn't be discussing any board business outside of an open meeting. Lunch breaks, anything. If you all go to the restroom from here, that's not considered part of the meeting. Business during those types of. Obviously, if there's something. Best item to be discussed. Typically, I will say our executive directors do a great job of making sure that everyone is on those emails. Electronically, if they're not supposed to be occurring during COVID. Obviously, we did meet that, and if there is an item that it is important. Some of you might be involved in professional. Obviously, if there is an article that is sent out to all licensees, that is something that may not be considered a communication that would be considered part of the public record there. I think it's a little bit too far away there. there any questions or anything that you all have questions about with whether or not something's a public meeting or records are considered public records?
As far as legal effect, your slide says nullity, but also doesn't the judge have the authority to require a report on your compliance going forward?
Yes, and that's a good point as well. There can be costs that are assessed as part of that with the cost of prosecuting that. So, if it is a decision that needs to be, fixed and put on a public, made through a public meeting, that can occur, but there are some costs that can occur as part of a judge's opinion or an order of the judge to make sure there's compliance with the Public Meetings Act. Are there any other questions about the Public Meetings Act or public records?
Thank you for the.
Okay. And I will also add, when we do get a public records request, that typically it is handled usually by our executive director and reviewed by legal. So you all don't have to review when there is someone is making a request for a licensing file or any complaints or anything that applies to that. That is something that our office handles internally. But obviously, if there was a question about documents that you all might have in your possession that could be a public record, that request would come through our executive director, making sure that we're complying with the Public Meetings Act. Well, that is all that I really have for that. If there's no other questions for the Sunshine Law, obviously it's on your devices if you all have any other questions about it, if you want to review that. But it should just be kind of a refresher at this point. So we can turn it over to any new business.
Thank you, Jesse. Appreciate that update. Want to share with the board that we had a sunset hearing on October the 19th. The board is continued for 1 year. Based on the request from the Governor's Operation Committee, administration will be holding a public hearing. Individuals that want to share their thoughts on the program's upcoming sunset will be able to do that at the hearing. They'll also have the option to complete a fillable form for comments instead of participating in person if they choose that route. The date and time hasn't been finalized, but proper notice will be given. We will add notice on the board's website for those that are signed up to get notified, which is one of the options under all the regulatory boards. Emails will go out. Industry organizations will be informed, and any others that are available. And so wanted to provide that update to the members. And then before we move on, Dana's on the Teams meeting. If anyone from the public or participating in person has any questions or anything that pertains to the agenda, as always, we would open the floor. And that is all the business that I had, unless you have any other questions. Dana, just making sure if anybody participating through Teams has their hand raised or has any questions.
So, thank you.
Thank you. They're going to need. There you go.
Just a very brief question. When you said you'd be giving proper notice, I wondered what that means.
So that means that once we have a date and time, there's, I believe, even a set number of days. We'll make sure that the board's website has that update. We have what's called Get Notified for our licensees, industry participants. It's an email system. If you're interested in contractors, real estate, barbers, or court reporters, you sign up to Get Notified. That's our email system that sends a blast. Those folks will get that blast as well. Notice will be sent via email to organizations. Definitely the exam providers will be notified, and anyone else that has voiced a concern or interest in knowing about the hearing date.
Well, that's great. I just wondered, was there like a standard number of days?
So typically for our rulemaking hearings, when we give notice for that, we set it out at least 52 days. So that way we've got plenty of time to meet with the statutory deadlines for giving notice to the public. With something like this, there's not really a requirement, but we thought that would make sense to give enough notice and to kind of use that same 52-day period.
The last thing that happened, on a Monday, finding out for a Thursday.
That wasn't our hearing.
Yeah, but I mean,
Proper notice will be given.
Yes, no matter who's hearing that proper notice. I was just curious what that was. Thank you.
Thank you.
Thank you.
And something else to add as well, we typically with our rulemaking hearings, there's a ability to make a written comment. So we will have a ability for that as well.
Thank you, members. Go ahead. Back to you. Thank you.
No, you're fine. My name is Amber Thompson. Helped a few people. Oh, okay.
Thank you.
So we've had 4 people that have applied to fill the vacancies on the board. We haven't heard anything about that. So we were curious in how that works now with this being the sunsetting and it being put off a year and then the requirements to fill it. And if you look online, it doesn't say that there are any vacancies. And our board contact is still someone who hasn't been with the state from what I've gathered in several years.
As it refers to your question on the appointments, those go to administration. The board office itself isn't involved with those. They have received them. They will follow the process they do with all the boards. We've got 25 regulatory boards. They have a set process that they do with any appointment. They go through then the governor's office and interview process. So they are received because they're done online. So there's no way to not receive them. They would follow those steps.
Okay. Is there any way to find out as far as us whether or not the vacancies are filled? And
they are not filled. Those vacancies are not. We had Stephanie Branham resign from the board. Korean Neal has resigned from the board. We have some expired terms, and so those vacancies are still active. I'll get with our web developer and make sure that we update and list them all as vacant. But they haven't been filled. So those people that filled out the application, they'll be reached by administration as the next step.
Okay.
Okay?
Thank you.
Thank you. Members, if we have no other questions and no one on Teams, I want to make sure to be courteous toward your time and travel back home. We would need a motion to adjourn.
Adjourn.
Second.
Thank you. We have a motion by Ken Mansfield, a second by Judge John Rambo. All in agreement of adjourning, please say aye.
Aye.
Thank you, and thank you for your time. I will put this right at 10 o'clock. Appreciate everybody. See you in March, and feel free to reach me if you have any questions. Thank you.